Hello, everybody. Welcome back to another live stream on the Craig Henry and Henry channels, respectively. I see a few people in the comment section already. Thank you for being here. Today, we are here to discuss my hearing that is going to be happening tomorrow in Greene County, Indiana at 8:30 a.m. at the Greene County Courthouse, the second floor. It's the Superior Court, Judge Martin's court. And we're here to talk about kind of what to expect, what's going on, and some of the buildup that has led up to this hearing. So I want to start off. Today, we're going to be talking about this prosecutor, Jared Holtzclaw, who is in charge of this case that he has filed. And it looks like he's the only public official that's signing off on these documents. It doesn't look like a court is ordering me to appear or signing off on any of these documents. It's just Jared Holtzclaw. And so I want to give you guys a little bit of an example about what's happening. Well, not an example, but I want to tell you all what's happening. What's happening is I published a video on my Henry YouTube page. If you're watching on the Craig Henry channel, you can find that video over on the Henry YouTube page. It's called Pro Se Motion to Dismiss Hearing. I posted that. I got an anonymous donation of audio footage from an anonymous donor, and I posted it to YouTube, right? Just to show people what happened in the courtroom. In response to me posting that video, which everybody can see it, it's still public. It's actually on the Lackluster channel as well now. But for anybody that saw that hearing, they know that at least in my estimation, I ruined the prosecutor's case. I mean, I made a complete fool out of him in the courtroom. And he didn't like that. So in response, he filed a civil filing against me. He wanted to have a show cause hearing in which he shows cause as to why I should be held in contempt of court and have some sort of criminal sanctions imposed upon me. This hearing is set for August 1st at 8:30. And a couple of weeks ago, I had another hearing out of Vigo County that was scheduled for the exact same date, 30 minutes later. Now, if you're from Indiana, you know that Greene County, that's Bloomfield, Indiana, and Vigo County, that's Terre Haute, Indiana, they're pretty far apart. They're about 50 minutes to an hour apart. And so basically it was going to be impossible for me to attend both of these hearings. Now, I want to show you guys a motion I filed because I filed a motion in the Greene County Court to actually have this hearing continued for a little bit. Because obviously, if I'm court-ordered to appear at one hearing, I don't want to miss the one that I'm court-ordered to appear on just to attend this hearing that the prosecutor has asked me to appear on. So anyways, I filed a motion for a rescheduling. I wanted it to be rescheduled on the same day to a different date. The reason I'm showing you guys this response, because this is the state's response, as you can see, to my motion for a continuance. So in response to this motion, the prosecutor filed a response, but then he granted his own response, right? He didn't actually submit it to a court, and apparently neither was my motion for a continuance. The prosecutor just took it upon himself to respond to the motion, then grant his own response, and deny my motion completely, which would imply that this guy is like a prosecutor and a judge, which is, it's obviously not possible. So we're going to read through this motion. This is State of Indiana, County of Greene versus Craig Henry. They've got State of Indiana 2 times up here, but this is just what the state does. They're pretty incompetent. So this is the state's response to the respondent's motion for continuance. Comes now, the state of Indiana, by its prosecutor for the 63rd Judicial Circuit, and respectfully states the following. 1. The respondent has received a notice of this hearing in the form of a summons that was issued by the clerk of this court. Now, this summons was issued by the clerk of this county, right? I don't know exactly if I know there's a court clerk and there's a county clerk, right? The court clerk handles the court stuff. The county clerk handles everything. That's the way it works in Indiana. So that's and look, this is par for the course for this attorney's office. I'm going to show you later in the video. They're bold-faced liars. They lie through their teeth about anything that comes up in front of them. And they don't care because they never get punished. So why would they care? So, 2, the hearing in this court was set prior to the setting of the hearing in Vigo County. The respondent has counsel in the Vigo County matter that requested the continuance that moved his hearing in Vigo County to essentially the same time and date as the hearing in this court for the instant matter. Now, I don't know if he's unfamiliar with the English language, but I think that was a misuse of the word instant. Maybe everybody can correct me in the comments if I'm ignorant myself. But then we've got point number 4. The state has witnesses with extremely limited availability and has already secured those witnesses for the morning of August 1st, 2024. Wherefore, the state of Indiana objects to the respondent's motion for continuance for the aforementioned reasons and requests any other relief that is just and proper. This has been respectfully submitted by Jared Holtzclaw, right? But then he goes and he signs it. He signs it as a certificate of service. But anyways, the judge has never actually ruled on any of these motions, right? The judge never rules on them. It's just Jared Holtzclaw. He just goes, your order is denied. And for anybody who thinks that I'm, misreading this whole thing, I am going to bring up the Odyssey notification that actually says, like, hey, your motion for a continuance is denied. All right. Now that's let's see here. I'm going to bring that up. Sorry if this is going to take just a little bit of time. Maybe I put it in the. All right, here we go. No, that's wrong. Well, I'll find it here in a little bit, and I'll show you guys what I'm talking about. But basically, the prosecutor has taken it upon himself to file with the e-notice system in Indiana that he's denied my motion, just all on his own. He doesn't need a judge. He doesn't need to submit it to a court. He wanted this hearing, and he's going to get it, right? That's basically what his thing is. All right. But, yeah, this is the thing that I'm saying. John DiNicola asked in the comments, where's the judge's order? Well, the thing is this court hearing wasn't actually set by a judge's order. It's an incredible thing. That's why this hearing is so important, everybody. And I want to remind everybody, I went live on the Henry channel, and now I'm going live on the Craig Henry channel. I'm inviting everybody to come to this hearing. This hearing is on August 1st, which is tomorrow at 8:30 a.m. in the Greene County Superior Court, which is on the second floor. All right. So if you want to come and see what's going on, I mean, they literally want me to come and prove my innocence. All right. But now I want to talk about the double standard that's apparent in this courtroom, at least. I mean, and I don't mean by the judge. I just mean that this prosecutor holds himself to a clear double standard. The standard is that his prosecutors, his attorneys are allowed to lie in open court. It's no problem, right? And that's the prosecuting attorney. He's allowed to lie, in an open court of law. But of course, me, I'm not even allowed to publish things that happened in the courtroom, even if I wasn't the one recording, right? I'm just not allowed to publish it. And that's something that violates the Indiana Constitution explicitly, because the Indiana Constitution protects explicitly our right to write and publish on any subject, whatever. That's what the Indiana Constitution says. And I don't think that the people that wrote that Constitution figured, oh, well, we'll just say whatever, and it will be well understood that you can publish on any subject, whatever, except for the courts, right? I mean, that's just the most ridiculous thing. The idea that we wouldn't be allowed to publish anything with regards to the government is a clear violation of our rights, but it's a clear violation of the government's duty to transparency and to protect our freedoms, right? But of course, they don't ever recognize this duty, and that's why here at the Henry Media Group, stick with me, we advocate for abolishing government, because as much as they make nice promises and they say, oh, well, without us, you'd be helpless. Well, in my opinion, it's never been that way. I think it's a huge facade that the government puts in front of us, and then they insult our intelligence if we think that we can survive without them completely controlling us and telling us what to do and violating us. But now I want to show you guys the proof of the prosecutor lying in open court. And we have more proof too, and we can show you that as well. So what we're going to do is we're going to show you this tab here. This is from a video that I shared just recently, but I am going to go over exactly what the prosecutor is lying about and point it out to you so that nobody has any questions. All right. I'm going to start this video and we're going to show everybody what happened. In an open court of law. Here is that video now.
First case is the state of Indiana versus Craig Henry. Okay, count one is resisting law enforcement as a class A misdemeanor. It states that the undersigned, having affirmed, says that on or about March 10, 2024, in Greene County, state of Indiana, Craig Henry did knowingly or intentionally forcibly obstruct or interfere with a law enforcement officer or a person assisting the officer while the officer was lawfully engaged in the execution of the officer's duties, to wit, Craig Henry shined a flashlight into my eyes during a traffic stop, obstructing my vision, contrary to the form of the statutes in such cases may be provided by Indiana Code 3544.131A and against the peace and dignity of the state of Indiana. Now, sir, that's charged as a class A misdemeanor. A person in Indiana convicted of a class A misdemeanor can receive anywhere from 0 days in jail up to 1 year in jail, anywhere from a $0 fine up to a $5,000 fine. Do you understand that?
Yeah, there's one question I have about this charge is it necessary that there be a forcible element to the accusation for this to have been charged to me?
We're going to go through a number of your rights here today. The court can't give you any kind of legal advice. One of the things you're probably going to want to talk to an attorney about if you hire one or you qualify for one would be the actual elements of the offense. Okay?
I'm more or less just asking to establish that the court, whether or not the court interprets that law to require a forcible element or not.
The word is forcibly.
Okay, so you do acknowledge that there's okay. That's the only question I have, Your Honor. Thank you. With regards to that charge.
Just to clear that up, Judge, I think that the statute actually says forcibly, comma, obstruct or interfere.
And it looks like there is a, something's been marked out, but it looks like maybe there is a comma.
Forcibly resist, comma, obstruct, comma, or interfere is the language.
And the reason there would be a comma there is because there's more than 3 things being talked about, or there's 3 or more things being talked about. In the English language, you put a comma when there's 1, 2, and 3, not necessarily to separate, but yeah, but to congregate those.
Well, not necessarily. The word is or, not and. Each of those would be separate and able to stand on their own.
After this hearing, I did a little research of my own and uncovered the fact that the state was lying. So I filed my motion to dismiss. This is what the Lackluster channel covered today. And if you want to find that. All right, everybody. So we're going to stop that video and I'm going to show you in case law where the Indiana Supreme Court said the exact opposite of what Brent Seymour said. And of course, it's the responsibility of a prosecutor to know the law before he charges one of his constituents with violating that law. And he totally it was a total dereliction of his duty. So what I'm going to show you here, this is Spangler versus State. This is on Gesteel law. And basically, what happened in this case was that a guy refused service from a police officer, and he got arrested by the police officer. And the court ruled in this case, let's see here. Let's see if I can. All this stuff is always so difficult to find. What they ruled in this case was that when interpreting the resisting statute, that what the prosecutor said, saying that every verb is standalone and that a forcible element doesn't apply to each verb, that's a lie. All right, so I'm going to find that for you all. But in the meantime, I'm going to show you some more lies that the prosecutor has said in a different hearing. We're going to share this tab, and this should be fairly quick because the prosecutor doesn't waste much time when he lies to courts. Of course, he doesn't care much. But this is going to be the prosecutor claiming that I was wrong in a court of law, trying to discredit me in front of a judge. All right, so this is it.
Yes, Your Honor. Yes, I would start with Mr. Hendry's last point as to the reason why he was revoked in, I think it was Vermilion County. The judge actually never ruled on the state's first motion to revoke bond, which was based on the Class A misdemeanor. The Vermilion County Court only ruled on the state's second motion, which only referenced the Class C misdemeanor, which is not the reason that we're here for today. So that is a non-issue as far as the state's concerned. The defendant also, frankly, misstated the law. The case law is clear.
Yeah, so that's a lie. What he just said about the court in Vermilion County, like the court in Vermilion County revoking my bond based off of a Class C misdemeanor. Not only would that be illegal, which this guy is completely ignorant of that law, of course, as well. That would be illegal if the court did that, because the law for bond revocation states that you have to have a serious offense. That serious offense is going to be a Class A misdemeanor or a felony, right? Now, to answer the question in the comments, I see, Craig, is this case in civil court or in criminal court? It's really hard to tell. It's very difficult to tell. There's no court order. I mean, as far as I'm concerned, this is between me and the prosecutor. There's no court involved. I mean, as far as I can tell, but we'll figure it out tomorrow. Anyways, I found the Spangler decision, and I'm going to show you guys proof that the guy is lying. So it goes, the fundamental conflict, and this is in Spangler versus State, the fundamental conflict within the Court of Appeals is whether the word forcibly modifies a required element of crime resisting law enforcement. Appellant contends that the Third District Court of Appeals interpretation is correct. While the trial court convicted the defendant forcibly interfering with a law enforcement official or persons assisting them. In overturning the conviction, the Third District Court of Appeals found that the use of force is an essential element of resisting law enforcement. All right, that because the word forcible appears on the face of the statute, that it modifies every verb. Right, so it says it right here. At trial and on appeal, Spangler argued that the word forcibly modified the string of verbs resists, obstructs, or interferes in the statute. Again, all right, and then they go, and then they say the use of the adverb forcibly before the first string of the verbs with the disjunctive conjunction used only between the last two of them shows quite plainly that the adverb is to be interpreted as modifying them all, which is exactly what I said in court, which shows that, I mean, it's an incredible ignorance amongst prosecutors. Many people don't know this, and they're very surprised to hear this, some of them, that I never even graduated high school, right? But even I have a grasp of the English language that allows me to interpret a simple writing of a law, right? That one must forcibly resist, obstruct, or interfere. All right, but the prosecutor who went to college, probably 4 or 6 years of college, he graduated high school. This guy can't even figure out how the English language works. Yet these are the people that we've tasked with enforcing the law. I mean, this is an absolute joke. This guy is so incompetent. I doubt he can wipe his own butt after he takes a crap. But now I'm going to show you more proof, even more proof, that this prosecutor is a lying piece of crap, right? So as you'll remember, the clip that we just showed showed the prosecutor claiming that the Vermilion County Court only revoked my bond on a Class C misdemeanor, and so it wasn't a big deal to him. Right, but now I'm going to show you the motion to revoke bond that was filed in that case. We're going to show you in writing that this guy is an absolute lying sack of crap, okay? This is the second motion to revoke bond. This is the last motion to revoke bond that was filed in the Vermilion County Court. Comes now the state of Indiana by prosecuting attorney Bruce D. Ackerman pursuant to Indiana Code 35-3385 and files its second motion to revoke bond. In support thereof, the state would show as follows. 1. The court granted the defendant's request to terminate the pretrial release and reinstate bail at the hearing held on January 31st over the state of Indiana's objection. The court found or the defendant to serve 24 hours in the Vermilion County Jail, and the original bond was reinstated. Okay. So what happened is I did get held in contempt on one occasion in Vermilion County. It was because I refused to comply with a pretrial sentence. Because from what I understand, I'm innocent until proven guilty. And if you don't exercise your rights, you don't have them. And if you do exercise your rights, you go into jail. You don't have them either. But on February 1st, 2024, the defendant posted the $10,000 bond with 10% cash authorized. On March 14th, 2024, the defendant was charged in the Greene County Superior Court, Division 1, for resisting law enforcement. Right? So it's funny that the guy says that this was never referenced in the state's motion to revoke my bond in Vermilion County. Yet we're sitting here, people. We're sitting here looking at the state's motion to revoke my bond in Vermilion County, and it directly references the Greene County Superior Court, Division 1, which is the court that we're in, for resisting law enforcement, a Class A misdemeanor. This guy is a liar. Now, I want y'all to keep in mind that I haven't lied to the court, right? As much as I don't respect the government, I understand the system and I understand how it works. And just the fact that the threat that's hanging over my head is enough to understand, to gain an understanding of the system. Right? But even I don't lie in front of the judge. Right? I mean, that's like law 101. Don't lie to the judge. But this guy's done it 2 times now. That's just that I can remember right now. Right? So Brent Seymour, the lying piece of crap, by the way, excuse me while I drink my Coca-Cola, everybody. But the lying sack of crap issued me a summons for publishing something on the internet. Okay. Now, the next thing I'm going to bring up is the Indiana Constitution. We're going to look at the Bill of Rights for the Indiana Constitution. And we're going to see if it says anything at all about protecting people's right to publish stuff. Now, I'm going to bring it up here. Bear with me, everybody. I know that I'm kind of shoddy with the live streams. All right, but here we go. This is Article 1 of the Indiana Constitution, as everybody can see up in the top left corner. All right. Now, I am going to have to read this kind of silently so I don't read it out loud and take forever. Okay. As a matter of fact, it didn't actually take very long at all. We've got no law shall be passed restraining the free interchange of thought and opinion or restricting the right to speak, write, or print. All right. Now, from what I understand, I was simply exchanging the happenings with everybody on the internet of what happened in the courtroom. Right? This is a matter of public interest, and not only that, but the Seventh Circuit Court of Appeals for the United States has ruled time and time again that recording interactions with public officials, recording courtroom hearings, is a constitutionally protected form of expression. Right? So whoever was recording that courtroom hearing was completely protected in doing so. Right? And that means that I was protected in publishing that hearing. Now, I'm going to explain to everybody how this works, right? Because there's a lot of people that will be in here. There's a lot of people who will be curious. Well, this is a contempt of court hearing that you're talking about. It doesn't say anything about, no courtroom rule shall be passed restricting this stuff. But I want everybody to understand that the courts receive their power from this Constitution, but then they don't receive their contempt of court power from anywhere else but the legislature. The legislature themselves has written up a contempt of court statute and granted the courts the power to hold people in contempt. Well, if an Indiana statute grants a public official the power to restrict someone's right, then that law that the legislature has passed is inherently unconstitutional. Now, that won't stop them from locking me in a cage tomorrow. Won't stop them from, locking me in a cage at any time, right? The only thing that would stop them locking me in a cage is people standing up and saying, we're not going to allow this to happen. But of course, it is a incredibly difficult task to say that or to do that in practice. So with that being said, everybody, the reason for the stream is to show you all, one, what is going to happen tomorrow, what the prosecutor is really saying. The prosecutor is saying that I violated the contempt of court statute, and I'm going to bring that up as well. That won't take me too long. Oh, we are being charged. I'm being charged with indirect contempt of court. So I'm going to have to bring that up. Indirect. All right. All right. So here we go. I'm going to share this tab here with you all. I'm going to let you all see it. This is the contempt of court statute for Indiana. And we're going to zoom in a little bit. Don't worry. We're zooming in. So he has, the prosecutor has accused me. And by the way, his deputy prosecutor is the witness in this case. So do I hear conflict of interest? Cheers, everybody. I mean, this stuff is crazy, criminal. Tomorrow, I really feel sorry for them for even doing this because they're just so stupid. And even if they throw me in a cage, all that it's going to prove is that they're tyrants that can't deal with stuff on an intellectual basis. They can't speak, so they just got to kidnap a guy, right? That's what they're going to prove, I assume. But this is the sections that he's accused me of violating. This is Indiana Code 3447-3-1, disobedience of process, and the second. So second one, a person who is guilty of any willful disobedience of any process or any order of the issue by any record or by a proper officer the authority of law, direction of the court, and after the process has been served upon the person. Now, number 3 is incredibly important. Now, and I could say that in order to restrict somebody's rights would be not anyways, right? And that would be an issue that we'd have to appeal probably to the U.S. Supreme Court or to the U.S. Appellate Court for the Seventh Circuit. Because the Indiana Supreme Court is totally on board with this stuff. They're totally on board with, ruining people and denying them their rights under the color of law. But then we go to Section 2, resisting or delaying process. A person who willfully resists, hinders, or delays the execution of any lawful process or order of any court of record is guilty of an indirect contempt of court. Now, people, this is pathetic. Right? They really haven't issued me any order. I mean, I guess the judge did just recently. I took a step into the courtroom, and the judge said, oh, hold on. We got people in the comment section tomorrow saying that the audio is messed up. Hopefully that's fixed for you guys. I don't know what I can do for that on my end. But basically, people, this is an absolute just travesty of justice. This guy, Brent Seymour, is embarrassed that he got completely embarrassed at this last hearing. And for anybody that hasn't had the benefit of seeing it, I think I might show the prosecution's response to mine just for the hell of it. And then my response to the prosecutor, because I think it's a healthy, beneficial exercise in thought. So here we go.
Your Honor. Yes, I would start with Mr. Hendry's last point as to the reason why he was revoked in, I think it was Greene County. The judge actually never ruled on the state's first motion to revoke bond, which was based on the Class A misdemeanor. The Vermilion County Court only ruled on the state's second motion, which only referenced the Class C misdemeanor, which is not the reason that we're here for today. So that is a non-issue as far as the state's concerned. The defendant also, frankly, misstated the law. The case law is clear that there's no requirement of physical contact, and I think that is in the double check just so I don't misspeak here. Well, City of Hobart indicates that.
Yeah, I want to comment on this here comment that I'm showing here. It goes, why don't you sue the prosecutor for malicious prosecution? The Supreme Court made it easier to do that. That's not off the table. Let me just put it like that. It's going to happen. I think I'll make it more inclusive. It's going to happen. These guys are getting sued.
That, and specifically, I finally found it, Walker versus State, which is 99 Northeast 2nd, which I referenced in my briefs, 2013 Indiana Supreme Court case. It held that the Supreme Court has never held that actual physical contact between the defendant and officer is required to sustain a conviction for assisting law enforcement. Excuse me.
Yeah. All right, everybody. Sorry about that. It looks like it really, the Wi-Fi is really screwing us over. I am going to just end the stream because if the Wi-Fi is going to be giving us problems, no reason for me to continue this stuff. We are going to have to just see everybody tomorrow. All right. Tomorrow, 8:30 a.m., Greene County Superior Courtroom. It's the second floor. Judge Dina Martin. Don't let them tell you can't come to a public hearing, people. All right. So with that being said, everybody, we will see you tomorrow at August 1st, 8:30 a.m. I've gotten a lot of RSVPs. I've gotten a lot of people telling me I'm coming. I'm so glad to see that. I hope that I can get a few more RSVPs before we see everybody tomorrow. And I think that if everybody can, I think that we're going to have a huge brunch event where me and everybody who comes along just goes out to brunch and we have a good old time. So I see a few comments that I want to address before I get off of here. First, I want to say, wake up and America and resist. This guy is just become a huge supporter of the channel, monetarily and a viewer. I mean, it's absolutely brilliant. So thank you to him. We've got Let's OTVO, link for court. I want to tell you, Let's OTVO, there will be no link for court. They will not Zoom record this. They won't have anything out to where the public can access this. They are trying to suppress this hearing. They want to throw me in a cage. They want to control the narrative. They don't want any recording of the event. They don't want anything to happen. All right. So it won't be broadcasted anywhere. Okay. And even if somebody did want to broadcast it, they'd have to go and ask the court for permission. And unless they are a licensed news agency or newspaper agency, they aren't getting permission in the Indiana courts because this system is so outdated and so unconstitutional. So with that being said, everybody, I'll see anybody who's coming on August 1st. I'll see y'all tomorrow morning. Best of luck to everybody else. We will see y'all. Take care.